So we will start with the gentleman from California, recognized for 5 minutes.
Good morning, Mr. Smith. When Attorney General Garland appointed you, he cited the particularly sensitive matters at issue and extraordinary circumstances as the reason for appointing a special counsel. What did you take that to mean?
What I understood that to mean is I was to conduct an independent investigation and come to my own conclusions about whether the facts and the law supported a prosecution.
But clearly he was alluding to the fact that we had an investigation into a leading candidate for president. That was part of the extraordinary circumstances. Would you agree?
I will rely on his public statements about that. I understood my role as special counsel was governed by the regulations, which required me to make an independent decision on my own.
So certainly you would agree it was important to approach the investigation with humility and restraint. Is that fair?
Yes, and that's what I sought to do. I sought to
conduct... And you thought you possessed those qualities. In fact, you testified at your deposition, quote, "I thought I was the right person for the job." Of course, some disagreed. Constitutional law professor Jonathan Turley, for example, has said, quote, "Jack Smith has a reputation for stretching criminal statutes beyond the breaking point." I assume you disagree with that statement by Professor Turley.
I do disagree with that statement. I think my career speaks for itself. I have been
But that statement was also, and I'm sorry to have to interrupt, I just have a short amount of time. That statement was also echoed by the United States Supreme Court in a unanimous opinion in McDonald versus the United States, where the court overturned convictions that you had pursued against a former governor, criticizing your boundless interpretation of the federal criminal statute at issue. That opinion was joined by Justices Ginsburg, Breyer, Sotomayor, and Kagan. So do you also disagree with that statement by those justices?
I have conducted my career in a nonpartisan fashion. That particular case, the legal position that the department took, that wasn't my personal position. That was the position of the department.
I see. So, Mr. Smith, I've had the opportunity during my time on this committee to review the work of two special counsels, John Durham, appointed during the Trump administration, and Robert Hur during the Biden administration. And in both cases, they seem to exhibit that humility and restraint that we talked about. But in reviewing in detail the way you conducted this investigation, I see a very different mode of operation. One that sought maximum litigation advantage at every turn, one that repeatedly circumvented constitutional limitations to the point that you had to be reined in again and again throughout the process. For example, shortly after you became special counsel, you issued a subpoena for the phone records of the Speaker of the House of Representatives over a 2-month period, along with for other senators and representatives, even though the public integrity section at DOJ cited litigation risk to doing this. What was that litigation risk?
With respect to the toll record subpoenas that we issued, they were approved by the Public Integrity Section. The Public Integrity Section, in approving those subpoenas, noted the fact that the subpoenas were for records for people who were not targets of our investigation.
But they said there was a litigation risk and you moved forward with it anyway. And not only that, but you also sought orders from judges making it so those who were having their records seized would not know about it. And you even didn't tell those judges that it was members of Congress whose records you were going after, in apparent contravention of a federal statute saying that a telephone provider for a Senate office shall not be barred from providing notice that the records had been requested. Now, if you sought to do that today, would you be able to get away with that, with asking the judges for a non-disclosure order without telling them these are members of Congress?
When we secured these toll record subpoenas, it was done consistent with department policy. You're correct in that that policy has since changed.
They changed the policy based upon the actions that you took. Similarly, you issued a gag order against President Trump that the D.C. Circuit Court of Appeals vacated as overbroad. Is that correct?
Well, the D.C. Court of Appeals, in passing on that order, found that it was justified. They narrowed the order, but they confirmed that the phenomenon...
They narrowed the order because it was overbroad. In addition to that, you sought an early trial date that the district court rejected, and when you presented your prosecution memo to Attorney General Garland, it's been reported that he was visibly unimpressed and expressed First Amendment concerns. So, Mr. Smith, looking at the record, I see that you were reversed and rebuked by the Department of Justice itself, by the Attorney General, by the Solicitor General, by multiple district court justices, judges, by the Court of Appeals, and by the U.S. Supreme Court itself. So my final question is, do you believe that you made any mistakes? Do you have any regrets as to how you conducted this investigation?
If I have any regret, it would be not expressing enough appreciation for my staff who work so hard in these investigations. We followed the facts and the law. These people who work for me sacrificed endlessly and have endured way too much for just doing their job. So if anything, I wish that I had thanked them.
I'm the gentleman.
No mistakes. There's that humility. Mr. Chair, I yield back.